Hello everybody and welcome to our first lesson on the subject of the law of tort. In this lesson what we're going to do is define and describe what it means to describe something as a tort, and then we're going to outline the scope of this series of lessons. So essentially this is the purpose of this lesson. It is to introduce the subject of tort law, and it is also to look at what it means to call something a tort, what are the characteristics of a tort, what is a tort, what isn't a tort, and then talk about the outline of the scope of this series in the future, looking at the various different concepts that we're going to be covering, the various different torts that we're going to be covering, as well as the order in which we're going to be covering them. So in following this structure, the first question that we have to ask is, what is a tort? What do we mean when we talk about the law of tort? And one of the interesting things here is that despite the fact that tort is one of the oldest and widest, most expansive areas of law, it is one that is less understood colloquially, or it is at least understood intuitively by people, but it is not necessarily understood as in terms of its definition and the way in which we address these issues. So, for example, people might know about the concept of negligence colloquially and intuitively, but they might not know that this represents a tort and what the word tort actually means. The word tort itself, if we're going to talk about just the etymology of the phrase, derives out the French meaning the word wrong, and this is really where we can find a more formal definition. A tort is essentially a civil wrong for which civil liability is incurred. And so the law of tort itself is a very wide-reaching and a very expansive in terms of the content in which it is covered. However, but for the most part, students, at least today, will be studying the law of tort and beginning with the first major tort, which is the most important in terms of litigation, this idea of negligence. Now, it should be noted, and we're going to note this in future lessons' time, that negligence isn't actually, or hasn't always actually been, the most popular and most heavily litigated area of torts. In fact, that prize went to intentional torts, the torts of assault and battery and false imprisonment, etc. But in recent years, at least in terms of the last 100 years or so, and some of the most landmark cases around negligence made it more of an open door for the ability for litigation to be pursued in this particular area. Now, a more concise definition can be seen here from Brennan 2017, and they say that a tort can be described as the area of civil law which provides a remedy for a party who has suffered the breach, of a protected interest. Now, the reason why I particularly like this definition is because it doesn't define and specify what each of the torts actually refers to. It just says a breach of a protected interest. And that essentially means that, given that that's quite a vague use of language, it means that we can essentially say, well, what is a protected interest, and what protected interest could be breached and therefore give rise to liability within the law of tort? Well, essentially, what the protected interest that we're talking about, for which a tort can be applied, will depend on the particular tort that we're talking about. There are obvious examples, so your reputation is a protected interest which is protected by the tort of defamation. So essentially, if we were to plug in the word reputation for the idea of protected interest in this definition, we would define defamation as the tort which provides remedy for a party who has suffered a breach of their reputation or damage to their reputation. And this is the tort of defamation, which is divided into both libel and slander laws. You also have protection of personal safety. That is a protected interest within the law of tort, and it is often covered by the tort of negligence. And we'll get to negligence in future lessons' time. Essentially, if somebody has a duty of care towards you, and they breach that duty of care such that the breach causes some kind of harm to your personal safety or damage to your personal safety, then you may have a claim within the tort of negligence. In addition to this, we have a number of remedies within tort. We're going to look at remedies in tort in a future lesson after we've covered all of the individual torts in more detail. But for now, let's just examine the way in which tort operates structurally and the sort of general philosophy behind the law of tort. And essentially, given the fact that tort is a wide-ranging area of law, one which encompasses a number of different acts, so you have nuisance, you have occupiers liability, you have vicarious liability, you have defamation, you have negligence, etc., etc. When it comes to remedies, there is often a sort of blanket remedy that is applied in most tort cases, which is, of course, damages by way of some kind of financial compensation. That is the general gist of what can be remedied within most areas of the law of tort. But this is not to suggest that compensation and financial compensation is the only way in which you can get remedy within the law of tort. To suggest that there are other ways in which damages can be applied as other remedies to various different torts. So, for example, a court might grant an injunction in certain cases of torts. So, one area where this might happen might be in the tort of nuisance. You can also have, if we go back to our previous slide, looking at our definition of defamation, looking at reputational harm, a formal retraction and an apology that is made public could also be part of the remedy within the tort of defamation. It often is in a lot of cases, given the fact that defamation protects the reputation of an individual against false claims. The use of a formal retraction and a formal setting of the record, shall we say, is actually quite useful within the tort of defamation. So let's think about the scope of this series in more detail. We're going to be dedicating a lot of our time to the study of the law of tort. This is going to provide a comprehensive study of this area of the law. And so in doing so, what we're going to do is structure out the content in the following way. We're going to begin by looking at an introduction to the law of tort. That is going to be the first major topic of this series. It's not going to be particularly long. We're essentially going to be talking about a lot of subsidiary issues which pertain to the nature of tort and tortious activity, including the concept of damages, the idea of insurance within the law of tort, the interactions between the law of tort and other areas of the law, such as that of human rights, the criminal law, and the law of contracts. So just generally taking an overview to some of the basic issues relating to the law of tort. And then in the second major topic, we're going to start to get into the first of our torts that are the most important. We're going to be talking about negligence. We're going to talk about the quote-unquote equation of negligence, each of the factors that are required to show a negligence claim and for a negligence claim to be successful. These include the duty of care, the breach of duty, and the standard of care. And we're also then going to look at a number of subsidiary issues relating to negligence as well, namely particular issues within the subject of negligence, the two most important of which are of course claims for psychiatric injury, the distinction and delineation between primary and secondary victimhood in this particular regard, as well as claims for pure economic loss and other kinds of economic loss such as relational economic loss or consequential economic loss. We will then finally look at the last part of the quote equation of negligence, and one of the issues that sort of transcends negligence and goes into a number of different tortious activities. This is this idea of causation. We'll talk about the idea of causation in fact, intervening causes, intervening acts within a particular tortious case, as well as the principle of remoteness of harm. All of this is very important for many different areas of tortious activity. We will then talk in the fifth topic about the delineation that can be made between acts and omissions. So what kind of liability can be incurred, not necessarily for an act that is done, but for a failure to act. We know from our studies of the criminal law, for example, that omissions does not necessarily bring a blanket protection from criminal liability. You can be held criminally liable for omitting to do certain actions. And similarly, in the law of tort, you can do the same. Essentially, we'll talk about the liability for omissions and the assumption of responsibility in that regard. We will then get on to the next of the major torts, which focuses on this idea of employers and vicarious liability. Talk about the development of liability for employers, statutory regulation of employers' liability, as well as vicarious liability, requirements for vicarious liability, and liability for intentional acts. Continuing on, we will then spend some time looking at the intentional torts which exist. These include the various trespass torts, so the rationale for an intentional tort, why intentional torts are actually actionable in the real world. The distinction between the law of tort and criminal law is something that is made very, very patently aware in this case. So there are various intentional torts. Specifically in this list here, we're talking about trespass to the person. This includes assault, battery, false imprisonment, as well as the tort of Wilkinson and Downton. And then we will talk about defences to trespass to the person before moving on to the final two trespass torts, which are referring to trespass to land and trespass to property, personal property. Continuing on then, we will talk about the tort of nuisance, the concept of nuisance, public versus private nuisance, as well as the case of Rylance and Fletcher, defences to the case of Rylance and Fletcher, and implications of the case of Rylance and Fletcher, before moving on to looking at the concept of occupier's liability. This is often codified in various pieces of legislation, so we're going to look at the Occupiers Liability Act of 1957, the Occupiers Liability Act of 1984, standards and duties that are set which arise out of the statute in relation to occupiers' liability. Section 10 will look at the tort that we focused on in previous slides, should I say, the concept of defamation. We'll look at what defamation actually is, the idea of reputational harm, the distinction that is made between libel and slander within the corpus of defamation, as well as proving defamation and defences to defamation. And then the final major topic is going to essentially summarize all of these different areas and talk about various defenses to tortious activities, limitations in terms of compensation, and remedies for tortious activities. So, defense to tortious action, remedies for tortious actions, as well as the principles of compensation. That is going to be the subject matter for the following lessons on this particular topic. Welcome back everyone to the Law of Tort. In this lesson what we're going to do is talk about some of the introductory principles of the Law of Tort, namely asking the question of what the purpose or the justification or the rationale for the Law of Tort may be. And this involves asking a question about the relationship between the concept of tort and some of the principles of compensation which exists. So, like I said, we're going to talk in this lesson about the concept of tort and the important rationale between the rationale behind, should I say, the nature of tortious liability. Essentially, we're going to be asking the question, why do we have the Law of Tort? What is the purpose of having the Law of Tort? And why is that purpose very, very important? Now, arguably the most important of the main justifications for the Law of Tort is the idea of compensation, the principle of compensation, as being the main justification for the imposition of tortious liability. Now, we'll talk about other reasons why you may justify the existence of the Law of Tort, but for the most part, this idea of compensation and principles of compensation really inform the fundamental bedrock and characteristics of tortious claims, and really show us where torts arise, how torts arise, and it will inform, for us at least, the principles of tortious activity, which lead us to looking at the different protected interests within the Law of Tort, and to talk about the various different kinds of torts that exist, which is going to be the topic of the next lesson. So fundamentally, we're asking the question, what is tort for? What is the purpose of the Law of Tort? Now, we noted in the previous lesson the definition of tort, a general definition, which is just simply the idea that we have civil wrongs which a claimant may be able to get some kind of compensation for, claim for damages, for example. And this is important for a number of different reasons. There is the idea here of wrongs, the idea of there being some kind of wrong that is done to an individual, and that individual can then claim a civil case, and therefore the defendant may be civilly liable for a particular damage that is caused as a result of the wrong that they had inflicted. So, for example, if an individual had negligently acted while they're performing their job, this negligent action causes some harm to you, there has been a wrong that has been suffered onto you. It was no fault of your own that you have now had some harm caused onto you. It was the negligent actions of the individual who were working in their job. And so the result of which is that you may have a claim in civil liability for that particular instance, and to essentially claim for damages as a result of that particular wrong that was done to you. And so the law of tort seeks to impose certain liabilities for action, for said action, in order to essentially rectify some of the wrongs which were caused by the action which was potentially negligent. Now, this is just using negligence as an example, because negligence is by far and away the most litigated tort. It is also one of the most important torts, and probably the one that every single law student begins with. We're going to begin with negligence in a couple of lessons' time. But there are obviously other instances. You have occupier's liability, nuisance, you have intentional torts, and you also have things like defamation, for example. Now, one of the things that is important is that tort has a number of different purposes and justifications, but they also have a number of different things that tort is not utilized for, or the rationale is not necessarily for this particular goal. So it does not necessarily suggest that tort imposes some kind of punishment onto the defendant. This is where you can make a delineation, for example, between the law of tort and the criminal law. The criminal law seeks to impose some kind of punishment onto a defendant who is found guilty of a particular offence. The law of tort doesn't do that. You may think that the resulting damages that an individual may have to pay, or the retraction of a statement that may have to be made by a defendant, is a kind of punishment. But the purpose of that particular imposition of damages isn't to punish the defendant. It's for compensation, which we'll get to in a second. So it means that this kind of idea of shaping society as a goal for tort doesn't really attract necessarily to the idea of tort more generally. So whereas with the criminal law, you could make the argument that one of the purposes and one of the justifications for the criminal law is to try and shape society in a particular way and to try and control behavior in a particular way, the law of tort doesn't necessarily have that purpose. Tort is not necessarily justified on the basis that it should deter others from acting in a particular way. Now, this isn't to say that tort doesn't have that result. People may be deterred from acting in a particular way, or may be extra cautious in their performance of a particular action to avoid liability in tort, but the purpose here is that it's not necessarily the end goal of the imposition of tortious liability. So, for example, the mere existence of liability for negligence, for example, may deter an individual from acting in a particular way. It may make an individual who is working on a job where they have a duty of care to make sure they take extra care and they do not breach said duty of care. And so that might be something of a deterrence for individuals to make sure that they are trying to avoid tortious liability. But the fact here is that tort itself is more concerned with the position of the claimant. And this is where we get the idea of compensation and the principle of compensation. So when we look at tort, and when we look at a successful claim in tort by a claimant, it involves some kind of loss which is incurred onto the claimant. So, for example, if you have a negligence case, if you have an injury, a personal injury case, for example, the injured party is the claimant, and the person who is wronged in some way is the claimant in this particular case. Now, this could be more than just personal injury. So negligence often involves personal injury. It could also involve psychiatric injury, which we'll get to in future lessons. It may also involve, in some cases, economic loss, and we'll get to the limited circumstances where economic loss can be imposed. It may even concern reputational loss in the case of some kind of defamation claim within the law of tort. But the purpose of tort is to essentially rectify, insofar as possible, the loss in question, to try and rectify the position that the claimant would have been in if they hadn't have had this tortious activity imposed upon them, essentially, or subjected to the particular harm. And this really gets to this idea of the principle of compensation, the view that a claimant should be compensated for the loss which was suffered. And compensation will often, and most often, take the form of economic compensation. So, for the most part, there is the payment of damages, but it could also be other things. So, I've mentioned earlier on the case of defamation. When you have a case of defamation, there is often the payment of damages in some cases, but there may also be, in addition to this, a full and public retraction of the false claims that were made by the defendant. That's a type of compensation in a way. So if you make a false claim to the public and the individual has their reputation damaged as a result of this, you may be sued for defamation or maybe threatened with litigation for defamation, and you may have to then retract that public statement that you had made. And that can be seen as a way of rectifying the kind of loss that was had if that particular piece of information that was false had continued to stay in the public domain without the rectification and the correction of the record. Now, the issue with the principle of compensation is this principle known, the Latin phraseology is restitutio in integrum, which essentially tells us that we want to compensate the claimant and bring them back to a position they would have been in, assuming that the tortious action had not happened. A very obvious example of this would be if, for example, you are a claimant and you have been negligently caused harm. So somebody has caused harm to you, and you have become injured as a result of someone's negligent action. And this harm and this injury means that you have been unable to work for, let's say, 3 weeks. Now, the compensation may be monetary payment, and the amount may be calculated on the basis of, okay, well, if you hadn't have had this injury, you would have been at work for this last 3 weeks, so we'll give you 3 weeks worth of pay, or you will get 3 weeks worth of pay as damages, as a result to try and essentially eliminate the conditions and to eliminate the consequences of that particular injury, to ensure that you have been brought back to the position where, assuming that tortious action had not happened in the first place. Now, that's a particularly good system, and it is clearly elucidated here in the case of Livingston and Royall's Call Corporation from 1880, when they say that compensation should take the form of the sum of money which will put the party who has been injured or who has suffered in the same position as he would have been if he had not sustained the wrong for which he is now getting his compensation or reparation. So that's the basic way in which we understand compensation, the principle of compensation within English law, specifically within the law of tort. It elucidates this principle of restitutio in integrum. When we look at how we apply this, however, to real cases, how effective can that actually be? There are situations where it is not particularly effective as a way to remedy particular torts. And we're going to get to this when we go all the way to the end of our lessons on the law of tort, because we're going to talk about remedies and damages and compensation principles in more detail. But it was worth noting that in this first early lesson that we just overview it quite briefly so we understand what the purpose of tort is. But we're going to get into all of this in more detail in future lessons' time. But for example, in the case of personal injury claims, it might be the case that in reality there's not that much monetary compensation that can truly remedy the wrong which was committed. So if something leads to the loss of life or permanent change to one's life, permanent brain damage, for example, a loss of a limb, for example, all of these things, you can't rectify that with a particular financial sum. So taking monetary compensation, taking a financial sum and trying to apply that to every single type of case within the law of tort may be difficult to do. In the case of defamation cases as well, you might have an instance where a retraction and damages is what is issued by the courts, but that doesn't necessarily bring the claimant's reputation back to where it originally was, because there might even still be people who believed the defamatory claims, regardless of if that statement had been retracted. And so this idea of no smoke without fire is obviously something that is quite difficult to shake off when you are being met with defamatory claims. So compensation isn't necessarily effective, and it's not necessarily an all-encompassing, perfect one-to-one comparison that you can essentially just throw money at a problem, and therefore we can bring that individual back to where they were if the tort had not been committed. But it is essentially the best that the law can do in terms of bringing back and bringing things back to how they would have been if that tort hadn't have been committed, even if in a lot of circumstances, or maybe in certain circumstances, it's not necessarily that effective. There's also the problem that the law of tort is reticent of the possibility that compensation may be indeterminate or even disproportionate. So there's a problem of being able to essentially allow for compensation, but to actually have a fixed number for compensation, and to ensure that the compensation isn't too much compared to the damage that was caused by the particular tort. We'll get into this when we look at the policy prescriptions around the idea of floodgates litigation at the end of this series of lessons. But for now, the next lesson is going to look at the different types of tort and look at the different kinds of protected interests within the law of tort before we move on to actually looking at the substance of the law of tort, beginning with the tort of negligence. In the previous lesson, what we did was examine the fundamental rationales behind the law of tort, specifically elucidating the principle of compensation, talking about how compensation is a fundamental principle within tort more generally. In this lesson, what we're going to do is talk about the types of tort which exist, and in so doing, we're going to be examining the different protected interests that exist within the law of tort as well. So, essentially, the types of torts which exist and the types of torts that we are going to be examining relate to the types of interests which may be protected by the law of tort, by a particular tort in question. So, as you will probably know, what this series of lessons is going to entail is a series of lessons covering a substantive amount of the law of tort. We're going to be talking a lot about negligence, we're going to be talking about occupier's liability, product liability, vicarious liability, defamation, nuisance, the rule of Rylands and Fletcher, the various intentional torts such as trespass. And so as a result of this, you can see that tort is not a single unified area of law per se. It is more of a subsection of various different types of torts which exist. Okay, you can study negligence, and then you can study occupier's liability, and then defamation. They all have a common thread running through them, and this common thread is elucidated in the fundamental rationales of tort. The idea that a tort is a wrong which is committed or which is performed in a way, and that wrong ought to be compensated by some kind of damages towards the claimant. So given the fact that we're going to be spending a lot of time looking at the various different kinds of torts, I thought it'd be useful to have a look at the various types of harms that exist and the various kinds of interests which are subject to the protection within the law of tort. Now, the most fundamental and foundational of these protected interests is that of personal injury. So the most common is, of course, the fact that you are protected in terms of injury claims and in terms of personal injury claims. This is done through mainly the tort of negligence. Negligence will protect an individual against unjust harms which are caused onto them. Negligence is also by far the most litigated of all of the torts, and we're going to get into negligence beginning in the next lesson, and we will go through and examine them in far more detail. But essentially, what the law of negligence did was begin its life around the 1800s and was something of a relatively insignificant tort which existed. And we will see the development and the expansion in scope of negligence when we look at some fundamental and foundational cases, specifically pertaining to the duty of care and the way in which the duty of care is applicable outside of, for example, a contractual obligation. This, of course, brings us to the case of Donahue and Stevenson, arguably the most famous case in all of English law, owing partially to the facts of the case being particularly memorable, or particularly memorable, if I'm going to use the English language, and so as a result of which we will get to this in future lessons' time. But personal injury and negligence doesn't necessarily just include physical injury. You also have individuals who are able to make claims for psychiatric injury. Now, this is a particularly difficult area of tort because psychiatric injury does open the door to litigation, and certain judges and commentaries on the law of tort, specifically on the tort of negligence, have made the argument that psychiatric injury can actually open the door, or could have potentially opened the door to potentially imaginary claims. Now, the reason why this is not necessarily the case anymore, or was never necessarily the case, is because psychiatric injury is very heavily limited in the law of tort. There are very many restrictions on who may and may not be able to make a claim within negligence for psychiatric injury. You have to have a certain, there has to be certain recognized psychiatric conditions that are ascribed onto you. You have to also make delineations between the kind of psychiatric victim you may be, i.e. a primary or a secondary victim. We'll get to all this in future lessons' time, but just note that psychiatric injury claims are particularly limited. But they still exist, and they can still exist, and it therefore means that when we talk about personal injury, we are not necessarily just focusing on the idea of physical injury. We also think about psychiatric injury as well. Another protected interest within the law of torts is the protection of your reputation. So the tort of defamation is the tort which protects an individual from the reputation, protects their reputation from false claims. Essentially, if an individual decides to make public untrue statements about an individual, which may be harmful to one's reputation, then this can cause them to be liable for either slander or libel. Now, the whether or not it's slander or libel depends on the medium by which you actually make those untrue statements, but they both fall under the general umbrella banner of defamation. So one of the things that is important to note here is that the protected interest of reputation is a public interest. So it is something that is protecting public untruth. So an individual cannot claim things to be said in private, which would make no difference to a person's reputation. So if I make a private accusation towards an individual, they can't then sue me for defamation. It is only when those are made public, and this is obviously something which can cause reputational harm, that we can then start to think about how defamation protects that individual. What about harm to property? There are various different torts which we can see in this regard. The protection of property is broad and very all-encompassing. You can have, for example, the protection of an individual's realty, i.e. real property or land. For those who are studying land law as well, we have lessons on land law that we are doing at the same time, running in conjunction with this series. We will note that there is a distinction that is made often between real property and personal property. The main delineation here is a delineation on the basis of whether or not third parties can be bound to the particular interest in that property. So realty and land is something that has the ability for individuals to have third-party binding towards them. And so the protection of property can include this idea of real property, real estate, land, for example, and also the protection of personal property. We can see personal property being protected by a number of what are known as trespass torts, so such as trespass to land and trespass to goods. You also have the tort of conversion, which we're not going to get into in too much detail in this series, but we'll get into in a series of lessons when we look at personal property law. Trespass to land and the rule of Rylands and Fletcher may be able to protect an individual's rights over realty, over real property, over land itself. And so you can see here various different torts which protect various different interests in property. Finally then, what about financial interests? What financial protection? What is quite interesting in this regard is that the law of tort offers relatively limited protection to an individual's financial interests. So, for example, the general rule in negligence for pure economic loss is that there is no claim to be had. There are various exceptions to this, which we will get to, but it's quite interesting that there may be some economic protection in the case of negligence, but there is also other torts which can have an impact on an individual's financial position. But for the most part, individual torts, such as the tort of deceit, will protect an individual from financial, or protect an individual's financial interests within the law of tort. Again, we'll get to all of this in future lessons' time, but for the most part, when we talk about financial interests, they are often attached to other interests that exist. So you'll find the protection of your financial interest may be attached to your protection of your physical, protection from physical or personal injury, or even reputational harm, for example. And so as a result of which, financial protection sort of is a thread that runs through many of the torts which we will be examining in more detail.